Hello, everyone, and welcome to our latest episode of We Get AI at Work. My name is Eric Phillipsburg, and I'm joined by my colleague, Joe Lazzarotti. Joe and I lead our AI team here at the firm, and that team really gets involved in all aspects of AI, from bias testing to policy drafting to the privacy considerations associated with AI and a host of other issues. We have a great episode today. We're excited to talk about it, and that is the Otter.ai case that some of you may have heard about in the news. So Joe, imagine this for a moment. You get an appointment for a business call. The time for the call comes along. You dial into the call. There's one of the meeting platforms that we're all very familiar with at this point. You log in, and you get started with the meeting. And you notice, or maybe you don't notice, that there is a note taker there. There's an AI note taker on the call with you, and you don't think much about it, and you go on to have the discussion with the other folks on the call. And maybe during that call, you're discussing some sensitive issues, maybe even some proprietary issues, confidential information. But because you're on the phone with trusted colleagues, you have that discussion because you're trying to solve a business problem. And then after the call, you hang up. Later on, you get a recording email to you, and maybe even a transcript of everything that was discussed during that call. And then lo and behold, you find out maybe later on that maybe some of the content of that call, including the content that you contributed to the call, is being used to train an algorithm or a model by a third-party provider who was providing the note taker to for your call, and now you're not really sure kind of where the information you discussed is. You just know that it's out there, and maybe kind of find itself in a model that you had no idea about. No one said they were turning this on. No one asked if it would be okay for them to do that. So, what do you think? What something like that happens to you? Kind of where are you going? What's the first thing you're thinking about?
Well, it definitely would give me a little pause. I know, we're very sensitive, right, at the firm to attorney-client privilege and that sort of thing. And I know we tend to try to watch for that. I think most folks aren't maybe thinking about that all the time. They're just jumping on a call and, like you said, trying to solve a business problem. I think what brought us here today was this Otter case in California that was filed in August, and I think interestingly, the plaintiff in that case was not a subscriber to Otter, and just happened to be on a call that they're alleging was recorded, and they're alleging a number of things that the call was recorded, information was accessed and used without their consent. They're alleging that information was the recording was being used to train their Otter's algorithm, and citing a bunch of laws like the Electronic Communications Privacy Act, the Computer Fraud and Abuse Act, and a whole host of California laws that they feel are implicated by this. And we'll see how that case plays out. But I think the way that you frame this is really makes a lot of sense, because there's a number of issues that come up with that in terms of, was it appropriate to record the call? Did the process for recording the call make sense and comply? And what was recorded? And, who has access to it? And what happens to that data? How long is it retained? Who is it shared with? I mean, all these questions come up that not only impact, the particular process of recording the call, but they may have unintended consequences. You may have shared information with a third party, in this case, Otter, right, or any other vendor. It doesn't have to be Otter, but that might violate some confidentiality clause that you signed off on in an agreement. I know there was and I think, I don't know, maybe it was you that told me about this. I don't recall, but you must know the story about like 6 or 7 people get on the call. One person doesn't make the call, but we're on the invite, and few people remain after everybody leaves, and maybe they have some not so complimentary words about the person who missed the call. And of course, lo and behold, everybody on the invite gets a transcript of that call, including the comments that the 2 or 3 people who remained wish never got sent, but the person who didn't make the call now sees that, and that creates a pretty significant dispute in the workplace. So, yeah, I think these are all issues that companies have to contend with as they deploy, or again, maybe not aware of employees using those tools or not sensitive to it face, and it's a significant issue.
Yeah, and I think that's right. I mean, because I think you alluded to this. There are the legal ramifications, and you mentioned, as attorneys, we're always concerned with applicability of privilege and being able to speak with our clients freely. And, if that information is out there, is that privilege somehow violated? And, and there are, again, I mentioned some of them before, some of the legal issues that apply this, but it also is an employee relations concern because look, we've all been on conference calls, and usually you get on a conference call in the beginning of the call, there may be some chit chat going around. There's no expectation that chit chat is going to be made public in any sort of way. Now, you would hope, and you would like that the participants are going to keep it business-like, but sometimes people may say something in shorthand, off the cuff, and now suddenly that's out there, and to the point you were making, could result in an employee relations concern. But so, Joe, just kind of thinking this through, though, how do we mitigate this? I mean, short of saying to whoever's bringing that note taker on, or even if it's a note taker arriving at the call, but it's not, tied to any one person, at least that's on the call, and us being able to maybe delete them from the call on the back end. What else can we do, right? How important would it be if we had a window pop up and say, hey, do you consent, right, to the use of this note taker? And, if you have, a half dozen people on the call, what if 4 of them say okay and 2 of them say no? How do you move forward? And Joe, I don't know if you have any perspective on that. I imagine that's not an easy answer from a logistic perspective.
Well, it does get difficult. You're right. I mean, I think for the most part, people follow that rule of like implied consent. If you get that pop up and someone stays on the call, they're consenting, right? I think some platforms you have to actually click that you accept the recording, and that click is captured and retained. But there's also the issue of, as a technical matter, suppose you're on a call with a patient, and they're now going to be disclosing information to the other person on the call, maybe their physician, maybe there's healthcare provider, and they have or their employer who's helping to manage claims, and there's a third-party note taker that's a third party, and is that person a business associate who's now saving that data on their servers? You have to go through that analysis and figure out, is that just having a consent to the recording sufficient? We've talked a bunch, right, over the course of many episodes about different compliance obligations. Another is the CCPA, right? Does somebody, because you're talking to, let's say, a consumer, and it could be an employee, that you're collecting their information, did you give them a notice? Is there a proper privacy policy on your website that contemplates the kind of data that you're going to now collect and record and transmit to a third party? And I think those are some of the questions. So it kind of goes back, I think, in my mind, Eric, to some of the governance things that we talked about, that you really want to, and I think you said this in a prior episode, is you really want to sit back and think about, what is this tool? What is it that we're doing? And kind of play out the scenarios, play out the use cases, and try to anticipate as best you can what is going to happen, what data is going to be collected, what notices or consents or policies need to be in place to ensure that you're minimizing your risk profile, your risk platform when dealing with these technologies. Because the funny thing about this is that this technology can be used for any conversation in an organization, And that could be employment, could be legal, could be, finance, it could be at the board level. And all those different conversations that are recorded come with a different framework of law and obligations that has to be thought through to figure out, is this a good idea?
Right. Yeah. Yeah, no, I think that makes sense. At least, but for now, I think the takeaway here is, and we talked about one case that's out there right now. I think the takeaway here is that, if nothing else, know that there are risks that attach to the use of note takers presently. Whether that can be mitigated fully by consent, I think it's somewhat of an open question right now, and exactly kind of understanding where some of this information is being stored is also going to be a critical component. I know for now. A lot of times if I'm on a call and I know it's something sensitive that needs to be discussed, I have that conversation right up front with the participants on the call to say, hey, here are some of the concerns that I have. Do we want to go ahead and leave that technology operating, or let's, not. So difficult issue. I'm not sure that we're necessarily going to solve it on this particular call, just so long as people know it's out there as an issue.
Right. No, I think it's a great discussion. And maybe it's a good place to conclude this one.
Yeah.
We'll see how the Otter case plays out and the other ones that follow it. I'm sure there will be something, but hope everyone who's listening found this helpful. If you have any questions or any thoughts about topics you'd like us to cover, please reach out anytime. You can contact us at ai@jacksonlewis.com, ai@jacksonlewis.com. Eric, always a pleasure. Thanks for presenting with me, and thanks for listening.
Thank you for listening to Jackson Lewis's podcast, We Get AI for Work. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient. We Get AI for Work is available on Apple Podcasts and YouTube. For more information on our topics, presenters, and other Jackson Lewis resources, visit jacksonlewis.com.